item 1501.
Appeal partly allowed sentence reduced to 7 years.
Right.
May submit. I may be granted permission.
Let the mentioning be over.
In this matter,
Is what do you want?
1501 itself. 1501 itself in judgment.
Huh.
I need a visitation right if lordship permit to mention for at least twice in a month
Visitation rights.
to the child.
That's a criminal appeal.
That's a good.
1501.
Rupees 25 lakhs to be paid within 6 months. And 2 lakhs to be withdrawn immediately. 2 lakhs with
Deposited
the
in the registry. Yes.
And divorce on payment of 25 lakhs. All litigations closed on proof of payment produced before the court.
2 lakhs by the respondent.
2 lakhs is already deposited, so that 2 lakhs, the wife would be entitled to withdraw, and in addition to that, 25 lakhs.
Within 6 months.
High Court, some matters are pending that.
All courts. All matters being set.
All matters to be closed.
Obliged.
Here he wanted visitation. bill.
He's one, where is he wanted?
Probably not that. Shall I read it, sir? We permit the child to complete the academic year. We direct the child to be retained in the custody of the grandfather till 34/20/25. While the child is continuing in the custody of the grandparents, we permit him to be taken by the father. The appellant herein on alternate weekends to reside in his paternal home. Child shall be taken on the evening of Friday or the morning of Saturday and returned on Sunday. This arrangement shall continue up to 34/20/25 till the custody of the child is handed over to the father on 1/5/20/25 in the presence of the jurisdictional station house officer. Grandparents shall have visitation rights after that every month.
Somebody was here, you wanted to mention something in this matter, we have gone.
Probably another matter. Maybe a given visitation rights.
Item 801.
Is it mentioning for not to be deleted minutes from the list?
Not to be deleted.
Wait.
Not to be deleted.
803.
Not to be deleted.
803 belongs, I appear for the petitioner. Here lordships have been referred the matter for mediation. The learned mediator now has fixed a physical meeting, my lords. She is a single mother taking care of a 3-year-old child and
Yes, so it
staying with her.
is showing on 18th of March, so let it be on 18th of March.
No, lordships, the matter is with the mediator now. At the mediation center, the next meeting is on 14th of February. He's fixed a physical meeting.
So what do you want now?
I want some cost for travel, my lords.
That is the learned mediator can direct it.
He says he cannot, my lords.
My lord, yesterday the learned mediator had circulated a message between the parties that on 14th, anyway, the mediation would not be possible. He is.
But he says
says
22nd, he is fixed it for 22nd, my lords.
उसमें इतना करके the learned mediator would also issue necessary directions to the husband for bearing the travel costs of the wife as deemed fit.
My lord, if I may. My lord, I've already placed documents. She is, as recently as last year, she has purchased a house worth 1 crore. She is making transactions. The bank account statements are also
my
on
lord.
record. Making that also I've
No.
placed on record, my lord. It's no.
No.
it's
Legal,
not-
let the matter be placed regularly. Not to be deleted.
Grateful.
Lordships, in the bail matter, notice was issued and my lords are directed for the matter to be listed in the next 4 weeks. But my lords, it has been beyond 4 weeks and
They are listed on 24th of February.
my lords, it was listed on, but my lords, no next date is showing on the website.
21st February it is shown. Not to be deleted, yes.
Obliged, my lords.
It's for five. Five voted.
It is for the,
It's a six.
May it please the court. Close the matters coming up on 6th
not
March.
to be deleted.
Sorry, Manoj. No, I don't want. All I'm asking is that 20th February to 27th February is the visitation for the child. We have no problem. But all we had sent an email because I didn't want to trouble my lords was that after 3 days, let her come back to me for a day and the next 3 days again. Let it be 2 blocks. But I've had no response, which is why I'm constrained to mention.
We are filing a response to the application, Manoj. Give me 2-3 days time to file a response.
The matter is not listed, so what order you can have?
That's why I'm mentioning it. And at least
That you decide, otherwise we will let the matter be listed, we will decide whenever it is listed.
then my learned friend can respond to my email because then.
He is saying that he will be responding in 2-3 days.
Can it be before the 20th then?
It is on 6th of March already.
Because the visitation begins from the 20th. My concern is this child is being very reluctant. At least I can make it into smaller bits. 3 days.
That will be again problematic. 3 days here, then 1 day here,
No.
again 3 days there.
Most likely he'll come back with more points.
More poison.
This is the mother's view, my lords, and I'm facing it.
Order is passed after hearing everyone.
Sorry, my lords.
Order is passed after hearing everyone.
True.
Yes. Next fact. No order.
Not to be deleted.
Not to be deleted.
And this matter may be kept on board. Elections have not even happened in the last. Elections have not happened in the last 8 years. It's a Michael's report is there, it has to be implemented. That's
Which elections?
Jammu Kashmir Association elections. High Court directed 2 months in 2017. We are in 2025. And Michael's report has come in January 2023. Giving recommendations in favor of the petition. I'm grateful for this. I'm very grateful.
Hello, my lord, the matter was listed on 10th of December and was passed the order list on after 6 weeks, but is not listed as education matter, and the policy is not drafted by the union government till today. So my humble request, it is an education
After
matter.
2 weeks.
Sir, otherwise, though, it will be time will be over. Date fixed.
It
Kindly
is
date.
after 2 weeks, we have already directed that.
Actually, I will be represented by senior advocate
Mr. Dushan Dave.
Sham Diwan and AOR PV Sarvanan Raja. The previous AOR, means she's a wonderful person, just like the amicus curiae who represented me in 2022, and also Daviji. But the prime reason I brought the case, we brought the case from Madras High Court in 2021 was for filing of the complaint letters and inquiry report that implicated me. And 10 years later also to UGC, that was.
What do you want, madam, now?
That Sham Diwan and PV Sarvanan Raja, AOR, they will represent me and they will ask for the urgency of the matter and actually in harassment cases and in
Yes, madam, you please,
medical negligence.
you please ask your,
That can be internal matter, but in private deemed university, after Supreme Court landmark judgment in 2015, still the inquiry report and complaint letters have not been filed, and no merit.
You please ask your AWAR to mention the matter, we'll look into it.
No, Sham Diwan will do it, sir.
Who is you are saying that there is some adequate.
PV7 this is, I mean, they are wonderful, this, but.
So please ask them to mention it.
No, PV Raja and Shyam Divanji. Shyam Divanji has been appointed by Supreme Court Legal Services.
Yes, you please ask some of either of them to mention the matter. We will look into it.
That's what I sent Shyam Divanji. But he was said actually because in 2022 the amicus query.
Yes, madam, please. We have already told you. Please ask your AOR or.
But the importance of the
Better call out.
filing of the inquiry report is the.
So this is a request we were mentioning Miller's matter. Miller listed as item number 43 before your lordships on Monday. Miller Sangan open a dispute. Miller, I'm requesting for an accommodation. Miller, the main counsel for the petitioner.
Today it is listed.
Miller, it's listed on Monday. Miller, is item number 43. Miller, just to bring it to the notice of your lordship.
Circulate letter.
Miller, I'll do that. Miller, in fact, the counsel for the state of Rajasthan has been informed. Miller, he hasn't no update.
Okay, yes.
Miller, can it be listed on 17th or 20th?
Very well.
17th is fine.
Malaks may mention.
I'm grateful.
Malaks may cover lordship item 55. Malaks, I'm being led by Mr. Sriram Verma on behalf of petitioner. He is in personal difficulty. Malaks, I have informed the other side.
Which matter?
Item 55.
I appear for the petitioner. I'm requesting for a week's accommodation. I'm in some difficulty today.
Okay. It is after notice or?
After notice, Your Lordships.
After notice, we are not taking, I think, notify. We are not taking after notice matters in any case.
It may be taken on a miscellaneous day only. That's my request, Malaks. So after week only. Obliged.
With your lordship's permission, item number 19 coming up on your lordship's board on Monday. There's a connected SLP. I'm only requesting that my connected SLP also will be taken along with it. It's defect circular.
I beg to differ the opinion. There is some delay in filing process. So very good.
With Miller's permission, may I mention item 62? Lordship is the after notice, but the stray round is ending today evening. Which is why this is a matter which was directed to be listed today. It may be taken today.
So who's for other side?
We've served this party's office as per the direction.
Great.
Great.
Your Lordship, may I please make an understood mentioning? Your Lordship, is a matter, writ petition number 82 of 2025. It relates to the Telangana MLA disqualification in the Legislative Assembly. Your Lordship had passed a direction to tag that matter along with the SLP. The SLP is coming on Monday, and the writ petition has been listed for another day. So, Your Lordship may kindly pass directions.
Yes.
Item 1.
Lords, I appear for the petitioner in this matter. Lords, the matter has been settled and we have filed a joint application under Article 142. If your Lordships have the IA number 30476, page 13, just to draw your Lordship's attention to the page 13, where the terms and conditions have been introduced. Page 13, para 3(2), where the parties undertook to file a 142 application, which has been done, my lords. Then subclause A, my lords. In the first installment, that is today, the respondent husband will hand over a demand draft to 35 lakh. The total amount which has been settled is 57.5 lakhs. 35 lakhs to be handed today, and simultaneous possession of the property has to be handed over to the respondent husband. The family members of both the respondent husband and petitioner wife are present at the location, and handing over of the possession of the vacant property will take place, my lords. And thereafter, my lords may fix this matter after 45 days, because the second installment will be paid thereafter. And matter may be the first installment today. I'm handing over the draft of 35 lakhs to my friends.
And the property has to be handed over by her to you.
Yes, yes.
Where is that property?
It's in Dehradun. So parties are there, my lords, authorized representatives.
The matter has been amicably settled between the party. The parties are personally present before the court. in pursuance to the settlement agreement, an amount of demand draft in the sum of 35 lakhs has been handed over by the counsel for the sworn husband to the petitioner wife. It is stated that the rest of the compliances as per the settlement agreement would be made within a period of 45 days from today. Post the matter after 8 weeks. 8 week covered date, specific date.
The afternoon, and state was filed the complaint.
No, I don't know, but charge sheet has already been filed below.
Why?
Charge sheet has been filed below on 31st of December below.
Sorry. This court wide order dated 19th of September 2024 has granted interim protection in favor of the petition. Very good. We are informed that the charge sheet has already been filed. So we therefore find that the custodial intervention of the applicant is not necessary. The petition is allowed. Order dated so and so is made as well.
Yes, my lord. These are also after notice matters, my lord. But they were in the sequence. My lord, their anticipatory bail, but there are two cross SLPs, my lord. We have challenged, my lord, the grant of anticipatory bail to them in one matter, and they have come up against denial of anticipatory bail in another matter. My lord, the short point is, I'm for the complainant. They take money from me, my lord, based on a sale agreement to sell, using which, my lord, they pay off the loan. There's a cash component and a check component, my lord. They deny the cash component subsequently, and now are refusing to come forward for sale. The High Court sent us to mediation, my lord. And in mediation, the difficulty is that they are completely denying, my lord, the cash component of the sale. Now, my lord knows we have a receipt, my lord, signed by them, which is filed along with our SLP also. My lord knows what is the reality of property.
Who is appealing for the state?
Yes, but it is a writing out of a complaint case, my lord. Initially, no FIR was there, my lord. They have registered a complaint before the court of CGM, my lord.
Yes, so has he responded? Has he attended the investigation in pursuance to the order? Have you filed a reply?
No, my lord. In the second SLP, my lord, we want to file the reply, my lord.
In this SLB? Manmohan Prasad SLB, have you filed a reply?
We haven't filed the counter, my lord.
You file a counter.
Very well.
How much time? Weeks time, granted. The respondent state to file counter. Put after 3 weeks.
Your lordships consider giving a returnable date because he has interim protection.
Yes. And what is this practice of before the petitioner starts, before the state addresses the complainant, is that the role of the complainant is at the most he can assist the prosecution. There are no independent audience.
I bow down, my lord.
How can you do more than 20,000? How can you do more than 20,000 in cash transaction?
I bow down.
My learned brother was suggesting that we should refer this matter to the income tax department.
My lord, may I say, being a government servant, he would be able to, my lord, give a justification for the source of the fund because he himself is a.
No, not
Source
the
of the fund. It is a penal provision under the Income Tax Act.
Any cash transaction beyond 20,000.
I bow down.
Would invite penal. You are a government servant.
I'm a DCP.
The more, we will allow the petition today itself.
I'm sorry.
The state had confirmed I will be cooperating. Twice they have taken time. They have orally on the last day confirmed.
Yes, my lord, if it's only a money dispute.
May I
No.
just submit now? Ultimately,
2 weeks, Mr.
I bow.
So much money.
Let's say it is anticipatory bail.
One crore 11 lakhs 43,756.
They will be very paltry amount, 10 lakhs. 10 lakhs was the first, only paid 10 lakhs.
And then he did not come to observe of this, they did not give an explanation. Not a case one. Not a case one. Thank you.
That time I want to present lordship.
Sorry.
I appear for the statement. Seeking a short password, we have already filed a counter affidavit. Ms. Swati will just stand in the opinion.
Yes.
Thank you, Senior Counsel Navy.
Case and counter. Case and counter. Case and counter case.
Not succumb to the injury after 11 days.
He's there.
Other screen. The screen before us is not there. Justice N.K. Modi, retired court commissioner.
Sir, I'm appearing, sir. Sir, I am speaking.
Yes, but you are not visible.
I'm sorry, my lord. My colleague may be permitted to argue, my lord.
Yes, madam.
It's a bail matter, my lords. I've been in incarceration for around 1 year, 3 months now almost.
Only.
Yes, my lords. There are
Sorry, my
25
lord.
witnesses in total. 8 have
My
been
colleague
examined, out of which
may be
majority
permitted
are
to argue, my lord.
hostile. And the two doctors
madam.
were the treating doctors as well. There's no role ascribed to me, per se, my lords. It has also come.
Petitioner makes a categorical statement.
My lord.
Makes a categorical statement that out of the 11 witnesses examined, 8 witnesses have turned hostile. Very good. You should notice. Written about points.
25 witnesses in total.
How many are examined so far?
Only 8 have been.
That's what we have said.
8.
We only recorded what you argued.
Video recording me. Similar allegations against the accused.
Notice.
Delay 75 days.
Control.
That I am coming up against an order rejecting anticipatory bail. But all witnesses, statements of all witnesses are based on hearsay. Only one person takes my name, and he is the principal accused. The police says that he has given a confessional statement. Self-incrimination is absolutely unconstitutional. But he has only taken my name. This is the situation. Entire evidence, witnesses, evidence are based on hearsay.
Dismiss.
Yes. May I withdraw then?
Yes. Allowed to withdraw.
Two ladies have been granted bail, my lord, and there's 2 persons have been injured.
You are not a lady.
No, I'm not a lady, but 2 persons have been injured from my side. I am not the main accused. The main role is on co-accused Sonu. My lord, there is a stick which has been recovered by the police from him.
What about 34?
34, my lord, I bowed down, lord. That is, but 1 year I am in custody. 7, they nominated 7 people. It's a family dispute. There is a civil dispute pending. 2 persons heavily injured from my side. I have annexed the injury report also. And there's a cross version also there, my lord.
Regular.
Only 1 year.
May I submit that I am not the main accused, the main
You may
accused.
not be the main accused, but something like
My
34,
family members have-
all of you go together, you carry lathis.
They visited my house, they have also got injured. There's a cross version. The 156.
So at the moment, even if taken at its best, it may be part 1 or part 2 of 304. Still not less than 7 years.
Some time will be fixed for some liberty will be granted after 6 months.
Yeah, we are not inclined to entertain the application at this stage. Entitled to renew his request after he completes custody period of 2 years.
Not before this one. Thank you. You are going to trial court, then high court, it takes another 2 years.
We should not only consider about yourself, we should also consider about your colleagues in the trial court and the high court also.
What's your list?
More the merrier.
Milas, I'm appearing. Made, please, Milas. Milas, I'm appearing on behalf of the petitioner, Milas.
Yes.
Milas, this honorable court, Milas, have been passing orders, Milas, in various SLPs that Milas, that bail applications, Milas, arising out of the same FIR, Milas, should be listed before the same honorable judge, Milas, in the High Court. Now, Milas, various High Courts have passed, Milas, circulars and notifications, Milas, regarding that. Now, Milas, what is happening is, Milas, in Jharkhand High Court, Milas, the matters are pending, Milas, even this petitioner's bail application is pending for the last 3 months, Milas. There are cases, Milas, where 6 months, Milas, the bail applications are still, Milas, yet to be disposed of, Milas. If the matters, Milas, the directions are obeyed, Milas, that it is listed before the same honorable judge, Milas, who has heard the one FIR bail application of one accused, Milas, so that may, Milas, help in the quick disposal, Milas.
Where is the direction to which you are referring?
Milas, may kindly turn to Milas, page number 63 for a second, Milas. There's the that is one such order, and there is other order passed by my lord also. That is with regard to Allahabad High Court. Page number 63, Milas. Para 6, that's the final, Milas, the observation. Now, taking note of the fact that such situations are occurring in other high courts as well, we are of the view that the register so-and-so be directed to communicate the order along with copies with all high courts on receipt. And at previous paragraph, Milas, para 4, that is the order passed by my lord. A 3-judge bench of this in SLP so-and-so take note of the situation. We have come across various matters from the High Court of Allahabad, wherein matters arising out of the same FIR are placed before different judges. This leads to an anomalous situation inasmuch as some of the learned judges grant bail and some other judges refuse to grant bail, even when the role attributed to the applicant is almost similar. We find that it will be appropriate for all the matters pertaining to one FIR are listed before the same judge so that there is consistency in the orders passed. Now, Milas, there is an order passed by my lord also, which is P3, Milas.
The learned counsel to the petitioner submit that in defiance to the orders passed by this court dated 31st of July 2003 in SLP criminal number so and so and dated 12th of November, December 2023 in SLP criminal number so and so. The matters pertaining to the same FIR are not placed before the same learned judge. First, it is submitted that this court, in unequivocal terms, has directed that all the matters pertaining to arising out of same FIR should be placed before the same learned judge. It is submitted that it is however submitted in the present case, though the order in the case of co-accused was granted by A judge, the application of the petitioner is placed before B judge. First, this court in a three-judge bench of this court in SLP number 1 has observed the paragraph 7. The said observations are also reiterated by this court, by a two-judge bench of this court in the case of Rajpal versus State of Rajasthan, SLP number 1 paragraph. What this court meant in passing the order dated 31st of July 2023 was that when there are different single judges, different benches to whom the bail matters are assigned, assigning different bail applications to different benches arising out of the same FIR leads to an anomalous situation in as much as some of the benches grant bail, whereas some of them take a different view. However, it is to be noted that in most of the high courts, the roster system is followed. After a particular period, the assignment of the judges changes. In many cases, it's also quite possible that the learned single judge was in earlier assignment taking up it quite happened that a learned single judge was earlier taking up the assignment of bail matters, may in the subsequent roster be a part of division bench. We therefore find that if the efforts of direction is universally followed, it may lead to disruption of benches in as much as the judge who had initially heard an FIR, a bail application from the same FIR, when application is filed by another accused in the same FIR, may be a part of a division bench. We therefore clarify that if in a particular high court, the bail applications are assigned to different single judges, oblique benches, then in that event, all the applications arising out of the same FIR should be placed before one judge, oblique one bench. This would ensure that there is consistency in taking the view, in the views taken in different applications arising out of the same FIR. However, if on account of change of roster, the judge was earlier dealing with the bail matters is not taking up the bail matters, the opposite directions would not be applicable. However, we expect that in order to maintain consistency in the views taken, the judges who subsequently hear the who hear the subsequently filed application may give due attention to the view taken by the earlier judges who have dealt with the bail applications arising out of the same FIR. And that if the if this is not followed, and if the judges sitting in the division bench or thereafter taking up different assignment are required to take up the applications arising out of the same FIR, now it may further delay the decision of the bail matters. Because the copy of the registrar general, the registrar judicial is directed to forward the copy of this order to all the registrar generals of all the high courts. The application shall be disposed of. Thank you very much.
Some direction for it early disposal at least, in this petition schedule.
At least we said that taking into consideration the urgency in deciding the bail matters, the learned judge of the Jharkhand High Court to whom the bail application of the present applicant is assigned shall decide it expeditiously. Uske baad le leंगे.
Grateful, my lords.
Yes, ma'am. Milos, I am praying for the anticipatory bail, where my anticipatory bail was rejected by the Punjab and Haryana High Court.
You go and obscene message.
Yes, Milos, I have no role to play in the commission of the matter, Your
No
Honor.
role to play except spreading those messages.
Milos, the matter relates to 7 to 8 years back, where some unknown person sitting in the foreign country was threatening the complainant, Milos, with whom I have no connection whatsoever.
Okay.
And secondly, Milos, the complainant has herself posted her photos, and I, being just the relative, just cautioned the uncle of the complainant.
You are related to complainant.
Yes, sir. Just caution.
Then why would she unnecessarily implicate you? Of all the persons?
That reason I do not.
That only God knows.
No, Milos. That
Yes, the God will answer that. Reject it. Yes, Mr. Naik.
So seeking bail, my lord, in an NDPS case, Lord, I'm in custody from 23rd of May 2023, about 1 year and 8 months. The case of the prosecution, there were two accused. I was found in possession of
67.66 grams.
Yes. But the commercial quantity is above 50 grams is commercial quantity. But what has happened in this case, my lord? At the time of seizure, my lord, two different pouches. One is containing about 50.20.
One big pouch and 15 small pouches.
Yes. As far as big pouch is concerned, the samples were not spent for this court has taken a view in one matter. Then the second quantity from which samples would be an intermediate quantity for which the section 37 would not come in the way of grant of bail. The co-accused has been granted bail on the ground that he was found in possession of small quantity. The charge is not framed. There were 14 witnesses. I am in custody for 1 year and 8 months. Lord, may I point out the FIR and
Since it is your first appearance, if you notice. No. Today when we are.
What happens is this, that when in the contract, if you were to have a mobilization advance.
Not a case participant.
One minute, I'll just try to.
Fabricated bank guarantee.
I am not a beneficiary of it at all. What happens is, if I want to get a mobilization advance, then bank guarantee was necessary. The mobilization advance was not released to me. I worked for about 30 to 40%, and thereafter FIR is lodged after 10 to 11 months. And Milord, what happens is, I lodge a complaint in the meantime. When I withdrew my application, first application. Thereafter, I lodge a complaint against the person who had issued this bank guarantee. Milord,
This department has produced the highest corruption in the state of Maharashtra.
I have no antecedent. So far as I am concerned, Milord, there are
Not a case for antecedent.
And I'll withdraw it.
Allowed to withdraw.
So,
should notice an identical matter.
Notice tag, yes.
Grateful.
Yes. Who is for the state? Yes, Mr.
May it please, well, it's the petitioner before your lordships is a housing board. Well, the property was acquired in 1990-91.
How much compensation you had paid in 1992?
No, Millers, I'm coming to that, Millers. I frankly submit that we have not paid Millers. Now it's not in a position to pay either. Millers on instructions. Millers, it's been constructed, Millers, long back 90. Millers, what I submit is that
You are a state.
Yes.
You are a state within the meaning of Article 12.
Indeed.
You grab somebody's property without
No,
paying.
first thing, Millers, that we are willing to give them land equal to that one of the same value because we have got the land bank. So that they could get instructions on that aspect. We are not running away from the responsibility.
By my senior, Mr. Rashish.
May I submit, my lord? Lord, the government has already initiated, my lord, the proceeding with regard to compliance of the order of the Honorable Court, my lord.
No, but he is saying that the houses are already constructed. So instead of that, he is willing to give you the equal land of equal value.
Agreed, my lord. I bow down to direction. Yes, my lord.
Rather than
I bow down
demolishing
to
this and you can construct a new one.
anywhere. Yes, yes, that can be.
Raipur.
Raipur.
Naya Raipur or Raipur?
Still is in the Raipur, my lord, not in the Naya Raipur area. Raipur city area. Raipur city, my lord.
Seshadri Naidu, the learned senior counsel, appearing on behalf of the petitioner, states that.
On instruction service.
It's always on instructions. On instruction states that the petitioner is not in a position to return the land to the respondent number 2 in as much as the houses have already been constructed and allotted to various persons. So he always submits that the petitioner is having a sufficient land bank. The petitioner therefore is willing to offer the piece of land having a same value as that of the land which is subject matter of consideration in the present lease. You give us, tell us so we can put it to them which land you are giving.
Yes, my lord. Yes, my lord.
So they can told Millers.
Who
Can be explored, Millers.
who is the person? Ask his officer.
Yes. Neetu Ganveer, what's his designation?
Which location otherwise?
One, Mr. Neetu Ganveer is the officer concerned who has instructed
But
us
who
that
is
they're
he?
waiting for
You
them.
give the name of the
We'll give
officer.
the details. We'll give the details so that they can talk to them.
Correct. The learned counsel was the respondent number 2 would get in touch with Shri Swanso, responsible officer of the petitioner, to work out the modalities.
Right.
You give the mobile number also, mobile number detail. You try to work out the modalities.
My lord.
Otherwise, you know what we have done in that Pune land.
Yes, we are aware of it. So I have come with a white kerchief. Grateful. So
that would also be something related to the.
Right. He said that don't offer him an alternative piece of land where you are again not paid a compensation amount to the land.
My lord is putting after some time, my lord, this matter.
Notice. Along with we have notice on behalf of respondent number 2.
Respondent number 4.
You are respondent number 4.
Respondent.
4 to 6, my lord, yeah.
4 to 6. The rest are the state government.
Yes.
This is state government, yes.
You should not, sorry, 16, there was nothing, the High Court directed the structure.
Great. Lordship is posting it after some time. Please.
When time you get in touch with them?
Very good.
Item 18, suffering because of a mistake of my counsel, order dated 9/8/10 was mistakenly filed as an order dated 9/10. And the order was passed as status quo prior to 9/10 shall remain state.
Now it's 2016, that's so order.
My lords, I understand, but
Therefore, the status quo creates a lot of difficulties. Either one should grant an interim relief or not.
my lord, I was granted interim relief, then they went.
Status quo only.
No, it was pursuant that I was asked to rejoin, but then in division bench, they said because contempt proceedings are pending, we will not interfere. Look, that order starts at page 50 at 88. It was said that because contempt proceedings are pending till 17.
You better pursue your writ petition. Get it final disposal.
My lords.
Very good. You are not inclined to entertain the present petition, however, the main writ petition which is pending before, the learned single day.
My lords.
We are not inclined to interfere with the present petition.
My lords, it may be untrammeled by observations in this case.
We, however, request the learned single judge of the High Court, before whom the main petition of the petition is pending, to decide the said petition expeditiously without being in any way influenced by the observations made in the impure order.
Most cases.
Land 5.06 acres was acquired 2 decades back, Your Lordship.
But the order passed by the High Court in effect would facilitate you to get the earlier, get the compensation early. Otherwise, the chair and if this chair is taken, what compensation you will get?
I'll answer that straight away, my lord. GREF, that is, they are also referred to as BRO.
Yeah.
BRO admittedly was, my lord, the agency which executed.
So therefore, the court has directed that the BRO, that is GREF so and so, should be implemented as a party respondent so that you will get the compensation expeditiously.
Your Lordship, to that is that the execution proceedings are going on, will now go on in 2 different districts. Sepahija and West Tripura, my lord. Because GIF again is located in another jurisdiction.
No, maybe.
BRO is located.
No, where is the land located?
The land is located in Sepahijala, but.
So the GRPF will have to come there from wherever they are to answer the contempt.
That's one aspect regarding the jurisdictional issue, but even other than that, you know, GRO has admitted, kindly have, my lord, page 79, Your Lordship, for a moment, the execution court's first order.
Are they party to the execution proceedings?
Yes, my lord, that's what I was showing, page 79, they volunteered to make the payment. Page 79, my lord should have. I'll show 79 and 80, my lord. Page 79, if I may just read the third paragraph, 8th June 2023 order of the learned executing court. It is submitted by learned counsel of the judgment letter requiring department, namely PWD, so and so, has already handed over the project to GREF, and so GREF may be made party in this case for making payment of the awarded amount. None of the parties raised objection against such submission of the present JD requiring department. It appears that for proper execution of the award dated 4th February 2020 passed by this court in so and so, it is necessary to insert the name of GREF as JD requiring.
Then you are not made GREF party respondent here.
It is in fact GRE in this order itself has said that they will make the payment within kindly have.
Therefore, had you made them party in this proceeding, at least we could have done something here.
Yes, they are a party. They are a party.
In the SLP.
Yes. They are framed. They are respondent number 2, Your Lordship. They've been represented in this manner. So we represented them as Union of India represented by officer in charge, rear next they are GRE.
If we issue notice to them, the GREF will not come before this court for next 6 months.
Well, the difficulty today is that it's an admitted case that they are.
If you want, we'll issue notice, but we will be doing nothing else but
issue notice because.
But we will be nothing else but prolonging your compensation.
The reason that there's a very recent judgment, Your Lordship, where Your Lordships have held that it's a bounden duty of the state, and the.
It is my judgment. It is my judgment. It is my judgment.
Justice Pardiwala's judgment.
You know, there's my judgment also last about two weeks back.
My lord.
With regard to land acquisition area. But then for that at least.
Reason why they are not.
For that at least you should make a proper party.
Well, they are a party, and they have pros.
Why don't we make GREF a party?
It's not a party here.
Why don't you?
They are, may I just show the.
Council, that's just Union of India. Why don't you implement the GREF here?
I will.
Please do that. Do that.
They have been arrayed in this manner, but I'll take steps not to implement them as well, Milord. I'm grateful.
You have to implement parties to the petition. The amendment will be carried out forthwith. Issue notice to the respondents returnable 4 weeks.
Deeply obliged.
He doesn't understand.
So I it is Siddhar Mailan and under section 131 of UP Jamidari Abolition Act, my lord, with its non-transferable rights, my lord. I can't transfer, I have no right to transfer.
No right to transfer.
Second appeal.
So file a suit against your father that he has no right to.
My lord, sir. No, my father, I know my lord. My lord,
Thank you. Business.
my lord, kindly.
No, thank you.
My lord, kindly just.
3 courts concurrently against you. What is the perversity? Please tell us.
My lord, my lord, kindly, I have not. My father has no right also because he is Siddhar with anybody. Therefore, my kindly section.
So make a claim against your father.
My lord, kindly.
Thank you, dismiss.
When this suit
Dismiss.
was filed, my father has filed suit, my lord. My father has filed suit. Not my.
The next part.
Substituted, but my father died, my lord. I am seeing. My father died.
We have already dismissed the matter.
That's not my.
So council, we have dismissed the matter.
This is a non-transferable right, well, kindly see.
Thank you.
On item 21, it's the petitioner is the DGGI, who is not a party in the contempt matter, my lords. And the initial RTI request is also not against the DGGI. And my lord, we were.
What, nothing is observed. Come to para 7. What is the?
12th February, the court is hearing everybody.
Grievance is that, my lords, our proceedings that we have initiated against the petitioner, even though we're not a party, is being regulated by the orders passed in the
Dismiss.
Please, my lords. I'm petitioner in person in item 20. My lord, the only question which has arose is whether the constitutionality of any statutory act of provision can be challenged in a PIL before Honorable High Court. My lord, I'm practicing. My lord.
You're practicing?
Yes, my lord.
How long?
1.5 years.
What is, in what way you are agreed with the
My lord,
your order?
I was before Honorable High Court in a PIL. I was personally not agreed from
Yes,
the review notice.
What does the law with regard to locus say? What does SP Gupta say? What does, you are a lawyer, what does this court in SP Gupta say? 1982 Supreme Court. Who can file a PIL?
Unless the person should not be
A
individually.
person who on account of his social and economic backwardness is not in a position to approach the court. Only in such cases, a third person would be permitted to represent him. You should be thankful to the High Court that it does not saddle any cost upon you.
What is the scope of such kind of public interest litigation has been widened by this honorable court?
So that the
My lord, it's
so that
not for any gaining any publicity, my lord. It is genuinely out of concern for the students as well.
so whether all the students in the state of Madhya Pradesh are not in a position to help themselves.
Because these students are of age of 16 to 18.
And their parents?
Whereas
They are
they
8
don't
to,
want to indulge in.
yeah, they are 8 to 12.
Whereas they don't want to indulge in challenging such kind of notification. That's why, my lord, a question of law.
If a person is not aggrieved, if a person is not aggrieved,
Please, my lord.
what locus you have to file on his behalf?
My lord, I am petitioner in person.
Okay. Dismiss with cost 25.
Please, my lord. I humbly order.
How many years of practice you have?
1.5 years, my lord.
Don't start your practice with such litigation.
Please, my lord. My lord, I may be waived off the cost, my lord.
Yes, we are not imposing costs. So don't worry about it.
Better affidavit for combination of claims. No doubt the High Court interferes with the contempt finding, but the delay part, my lord, I myself.
Oh, but then 1/3 each to.
This all trial court and appellate court held that it's a self-appellate problem. And
You don't want to give anything to your sister. Thank you. Dismiss. Don't be so greedy.
Years of age, and he's being harassed despite your lordship's specific direction to pay in 3 months. They are not complying.
No notice. Written out 4 weeks. 4 weeks, yes.
I not see this, my lord. Fortunately, the court has observed, my lord, there was no sufficient reason to condone the delay, my lord. This is actually a first appeal that has been filed, my lords, against the order in which my land has been acquired, my lords. And the entire premises of the judgment.
You have already filed the execution. And then you also filed a writ petition.
Okay. My lords, can we see the fulcrum of the case actually comes at page 47, my lords.
So the degree is for satisfied.
My lords, kindly come to page 47, my lords. The entire fulcrum of the case is that this was out of a Lok Adalat settlement. Of a Lok Adalat settlement regarding the nature of the property and the extent of the property. My lords, may kindly come to that, my lords, at page 47 for a minute, my lords. Para 4. This is the finding of the learned trial court. Subsequently, the plaintiff filed an application for. Please, my lord.
Page 6. Para 8.
Page 6, para 8. Please, my lord. As it's gatherable, my lord, sir.
Yes.
Gatherable from the above discussion, after the decision was rendered in the execution petition, thereafter petition, the applicant is now seeking an extension of time in filing the appeal to challenge the judgment and execution.
Yes, sir.
My lords, what I am respectfully submitting before my lordship is this, my lord. The entire decree is based out of a compromise which actually failed, and the suit was revived. That is what I am trying to show from my lordships in page 46. Well,
thank you.
My lords.
Thank you.
Just for a minute, my lord, just have that page, my lord, just for my satisfaction, my lord. That's page 47, para 4, I just leave it at that. I'm obliged, my lord. Just that part. My lords, I'm trying to read page 47, para 4. Subsequently, the plaintiff filed an application for revival of his suit in accordance with the Lok Adalat award dated 23rd November 2013. Pursuant to the rejection of his application for reference in matter of section 18 of the Act to the extent as agreed, and the compromise entered into before National Lok Adalat 23rd November 2013. This court, while its order dated such and such, restored the suit to the original number in view of the report of the defendant number 2 collector dated such and such submitted before this court, revealing that the application for reference even to the extent mentioned in the compromise was rejected. And my lords, this suit got revived, my lords, and the entire suit is now based on this compromise. So this issue is not at all agitated. This issue regarding the extent of land is not agitated, my lord.
Thank you.
My lord, my statutory appeal may not be
Thank you.
taken away on an issue of.
You said 1 minute, we are granted to 2 minutes.
Obliged.
Trial court had decreed the suit for equal participation.
Rightly, you, out of the joint property, you sold it and then you say that of the remaining, I want 50%.
Deducted when the trial court decreed the suit for equal, that part was deducted. I am not asking that. And I'm an agriculturist, I had needed money. That time also he was not ready for partition. That's why I have to sold out. Because of my poverty, I did this.
Okay, thank you, madam. A very equitable order. Thank you.
By Mr. Manoj Kumar Mishra, sir.
Where is he?
Agreement with his family. So I'm seeking an accommodation.
His name is not there. Some Mr. Himanshu Shekhar Tripathi is Revar. Revar are only for the purpose of filing Wakalatnamas.
Lordship, I'm seeking just a short accommodation.
Fortunate. We should. You should at least circulate a letter yesterday.
There was no provision with respect to that.
We should have mentioned it. We are permitting mentionings. Monday. We are only postponing. We don't want the dismissal to go in your name.
Petitioners are the defendants. And defendants.
Defendants 3, 5 to 7.
Yes, madam. When the order of cross-examination was commenced, when the plaintiff was there, we followed it strictly. When the defendant was examined, DW1, I said, I am the adversary. Persons who are sailing with the plaintiffs should cross-examine first, thereafter I should do that. Otherwise, my cross-examination may be diluted if you allow them to cross-examine little later. And that is, the note papers would indicate they kept quiet, they did not cross-examine. I cross-examined the witness extensively.
Yes, the court has already observed that the value of the testimony would be considered at an appropriate stage.
But that is, you are too pleased to visualize. In an identical circumstances, I came before this honorable court. Your lordships are pleased to issue notice. But is a connected matter.
In this matter?
No. Connected matter, Nalanda.
No, in this matter. In a matter arising out of the same suit.
Same estate. That is a testamentary proceeding.
No,
that is arising out of testamentary proceeding. My contention is normal line of succession is intercepted by testamentary disposition.
Arising out of the same proceedings between the same parties.
Yes, sir.
Notice is issued arise.
Yes, sir.
Where is that notice?
That is SLP 26326/2024 by the Lordship Justice Ravi Kumar and Sanjay Karol on 11/11/2024.
Page number.
That has not been enforced here, madam. I'm sorry, madam. My friend is there, madam.
Yes, where is that order?
Actually, that is an aspect of this between the parties. Nothing to do with this. So far, this
Dismiss.
That order.
Ordered a flat. Then they asked return on my money. 50 lakh they paid. 50 lakh they were returning.
5 years.
Training they issue. I made an offerment. Then if the work availability they permitted that they said they return it. Then they sent a legal notice saying that I have legally taken money of 50 lakh. That's the only.
When did you challenge? After how many years?
I have challenged it. I have challenged the lordship in
Page 4 writes that.
11/7/19.
Only the state, so if you can get some more. 50 lakhs for how much period you waited?
Is what exactly? Because I mean, ladies, because I don't know.
What is the averment in your plaint?
My averment is the case that is also being reflected in para 2 of the.
No, to bring it within limitation, what is your averment in the plaint? Verbally.
When they promised it, the illegal notice that they say, the 50 lakhs of taken is the cyber money, which if I showed them the document I didn't. Then only it came to know that they did not take 50 lakh rupees.
Siphoned off.
They said, what, 50 lakh, they said this 50 lakh is not your money, or siphoned. This is a legal notice.
Where is that siphoned off?
The society.
Where is that siphoned? Don't argue anything then.
From that point, I came, I also so I came to the city for finding the court. What information? What was there in the last? What was there?
Issue notice. They will forward it.
The mechanical order is passed, my lord, contrary to section 96, order 41, 31. Your lordship says the appellant before your lordship is the original plaintiff, and the defendants, my lord, are all of them are sisters, my lord, 4 sisters. Now your lordship says, my lord, the error in the second appeal, my lord, your lordship may update this main fact, my lord. One is main question of law is, my lord, order 41, rule 31 is not followed at all, and I have placed your lordship's judgments, my lord. And the first appellate court, my lord, passes a 1-page order. Number 2, my lord, the first appellate court says sale deed should have been challenged. My lord, various other questions of law. Your lordship may have a look at page. Impugned order, my lord, starts at page 1. Last page, your lordship, my lord, only half-page order, 1.5-page order, my lord. It starts at page 10. Page 9, my lord, your lordship says the contention of the plaintiff is that when she was not paid so and so, she verified the so and so. Sale deed, document number, page 10, page sale deed so and so. Even then also she did not challenge the sale deed. Your lordships have time and again said, my lord, question of challenging the sale deed does not arise. Only to the extent of her share, she is able to. Now the court says, my lord, the property did not belong to one of the sisters, but yet, my lord, it says the sale executed by the son of one of the sisters is valid. And the court also, my lord, records the finding that it belonged to one Ghulam Samdani, not these people. So my main point is, my lord, it's a mechanical cryptic order, my lord, which is not supposed to be passed under section 96, my lord.
Thank you. Dismissed. Bill of 93.
4 judgments have, next 4 judgments are filed, my lord, wherein your lordships have clearly held that question of challenging the sale deed doesn't arise. One judgment your lordship sees, my lord, there your lordships have said it has to be, my lord, as per section 96. 96 means, my lord, the evidence has to be reappreciated. That has not been done, my lord, only 1-page order is passed. That's why respect.
You're talking about which matter?
Lord, item 13.
I think we have already dismissed it.
Bill of 99.
Limitation in this question of
In this matter,
question of law and fact.
no, it is a question of fact, law here.
Law and fact.
No, here it is matter, Lord, it is a law in the sense, Lord. Petition is barred by the limitation as per the argument made by the petition in the probate application, Lord. In the probate application, Lord, the probate application was filed in 2017, Lord. That of the testator was appointed in 1999, Lord. After 18 now, it is stated in the petition itself, Lord. And the High Court has committed an error, Lord. This is the High Court order, Lord. In para 5, Lord. Para 5 and 7, Lord, where the High Court has committed a grave mistake, Lord, that may I read from the petitioner in the main petition and the respondent herein oppose the application on the ground that the limitation of the year as provided under Article 137 of the Limitation Act 1963 commenced from the date
when there is an objection raised to the will, reliance has been placed so and so, it has been disclosed in the petition. It has not been disclosed in the petition block. I will come to the petition block. It has been disclosed in the petition that Sri Lal Chand so and so, the elder brother of died on so and so, and his after his demise, the will dated so and so was found in the file from the trunk. The will was discovered. It was not in the petition block. Kindly see the petition block.
Yes.
Petition is a P1, 25 page 25 onward block. In the entire petition block, though no single averment about the trunk block where this will was found. So when there is no averment in the will, probate petition block, this fact is not disclosed in the probate petition block. I had raised this objection at the first stand in my WS block. I filed a 711 application block, and then only on this ground that this will was found in the trunk in 2015 Lord, my application was dismissed by the High Court Lord, which is factually wrong Lord.
There is no averment.
There is no averment at all. There is only 3 pages note.
On the perusal of the averment, so from the perusal of the probate application, it would reveal that there is no averment as to how the application is within limitations. That view of the matter. Issue notice.
Yes, say blood because
Stay of the proceedings.
it is going on blood.
We have said stay of the proceedings.
Please, man.
Thank you. Very fair on your part.
See, that sustenance kind of alarm, that's why we have taxed.
I searched through the 3 orders.
Well, 2 aspects, my lords, which have done it in single bench or division. Both have not gone into that.
Ames board.
Ames report come on 7/10/2021. That is after 15 months, my lord. If you lordships look at the certificate.
So in 15 months, the disability changes to 1% from 40%.
That's interesting. Please see the certificate, my lord. Certificate says, my lord, the condition is likely to improve. And petitioner himself is a doctor, my lords. So with the passage of a time, my lords, and with the treatment, my lord, this condition may be improved.
Thank you.
That's after 15 months. But my certificate, I don't say, my lords, has not been.
You don't report to the hospital there for examination. You are given 8 days period. And then
he waits for it to improve till 1%.
But the report of the hospital has yet not been submitted. Where I got.
You don't go for the examination. Thank you.
My admission is subject to the verification of disability certificate. That certificate has yet not been examined by the authority who is issued the certificate.
Yes, thank you.
Report. Thank you.
Yes.
Being by senior advocate Rahul Hudson, who is online. Is everyone?
Who is the senior advocate?
May I please, my lords?
Yes, Mr. Haq. You want to become a perfect doctor?
Lordships, the humble request is that this batch is also affected by the pandemic.
Oh, pandemic was in 20.
No,
after 20, you got 4 attempts.
Lordship, the entire right from the beginning we suffered our studies. Lordship, I can point out on facts about that. What happened that
yes,
the admissions took place till March 2022. Then the classes started from April 22, and I have stated in my petition that WHO itself declared that the public health emergency of international concern PHEIC ended on 5th of May 2023. Lordship, I am praying for the same yardstick as applied
if my lord have a kind look at page 138 of the paper book. May I read, my lord?
Unfortunately, today is your first appearance, so we are only postponing the dismissal.
Oblige, my lord.
Notice, no, 4 weeks.
Oblige.
So next day, don't appear. Mr. Ahad, we said that on the next day, you please don't appear.
Okay, lordship. I will take care.
Yes.
The company was not in the queues when the complaint is filed. High Court says filed an impediment for making the company. Can't be impeded because it's a criminal prosecution. Can't cure it. It's not some civil prosecution that you can impede.
Notice.
I'm paying for stay.
Stay of the person.
The petitioners undergone Millard's 7 years, 1 month Millard's. Whereas the independent witnesses Millard say that nothing happened in front of them, they were asked to sign blank seizure.
After 6 months, it's 1.5 years.
So grateful for this.
Please, Your Lordship. Your Lordship, I am against an order of Madras High Court where a contempt petition was filed by the petitioner, who's a lawyer himself, against the Madras police official. However, a cryptic order was passed by the Honorable High Court, and Your Lordship, at page number 3, which is impugn order itself, the para 5, the High Court has pointed out that the section 41A notice, if it was not given, it was just a procedural lapse on the part of the police official. If
Such contempt petitions have to be entertained. Thank you very much.
Your Lordship, the only point here is that
Yes,
if any,
you have argued very well. Thank you.
Your Lordship, the only point here is that it's not the question of only the petitioner, it is the power of the Honorable Court as well, that they have issued some guidelines which are not followed. And para 11.7 of the Arnesh Kumar judgment specifically says that the contempt proceeding shall proceed. By the interim order, the charges were framed by the Honorable High Court.
Thank you. Thank you very much. The victim is unshaken. The medical evidence also supports. There are Hamon drawn and there are.
I am on the point of quantum of sentence. The sentence awarded is life imprisonment till end of natural life. Lordship, under section 6, minimum sentence is 20 years. In fact, Lordship, in one of the judgments in which I was also the counsel in the connected matter, that was Sanghu Bhai's judgment. Lordship had awarded 20 years sentence. Under section 6, the minimum sentence is 20 years, which may extend to
Quantum of sentence.
I'd like to seek an adjournment here due to the advocate on record has health issues. My lord, make.
You already adjourned from time to time.
My lord, this is my lord may give us the last opportunity. My lord may have it on next Friday. Because of her health concerns, she could not make it, and I actually moved in adjournment slip. However, that could not come on record. My humble request, my lord, just be adjourned for 1 week, my lord. For Friday.
Sir, 34 is against you, 37 is against you.
My lords, may just have it coming Friday, my lords.
You'll have it on Monday.
My lords, may have it on Friday.
No. I'll stand over to Monday. I have last chance at the request of the petition. No. Yes.
Your Honor, away of medical emergencies, we just rushed now.
What is the medical emergency?
In his family, Your Honor. Fallen from the roof, actually.
Huh?
Wife fallen from the roof.
Right from the roof.
Yes.
No, Monday.
Yeah, maybe it's not.
Monday or
Yeah, Monday.
Monday week.
Announcement by the High Court. The reference code, my lords, considering the exemplar being the survey number under the same notification, my lords, at page 70-71, had granted 28 rupees 20 paisa.
22 rupees 80 paise.
It comes to because of 1/4 reduction index, which is at page 70-71, my lords. Whereas the High Court was de-escalation from 2004, my lords.
Yes.
If my lords see page 70, what it is relevant to note here that the spot number 2 in its objection at para number so and so specifically contended to acquire land herein, and the land bearing survey number so and so situated at Vaindevar village have been acquired under the same notification. LAC 18 of 2005 registered in respect of the above said land bearing the survey number. That case disposed of on 1/4/2008, and the market value of that land is fixed at 28.20 square feet. Whereas the High Court in the appeal at page 18 does de-escalation.
No, the salary show 105. I could have granted 44.
44 minutes.
We'll entertain if the appeal comes from the other side. We'll entertain if the appeal comes from the landowner's side, not at your base.
Called upon the state to seek instructions at this point. This is regarding the rehabilitation.
Yes.
Mr. Lordships, I have sought instructions. Your Lordships, I have copies of the recipes that we have circulated for early listing, and the High Court has issued notice and has kept the matter on 21st February 2025. So, Your Lordships, it is listed on 21st February for hearing. I may speak from the review.
This will go on endlessly. That's the difference.
Correct. In the present matter, the contempt petition, the High Court, by the imperial order, has postponed the hearing of the contempt petition on the ground that the acquiring body, who has filed a review, acquiring body or the state? The state has filed a review seeking file an application seeking review of the judgment, of which seeking review of the judgment dated 10th of November 2022, of which contempt is alleged. Paragraph. The petitioners whose lands are acquired cannot be made to wait indefinitely for allotment of the alternative lands as per the provisions of section 16 of the Maharashtra Project Affected Persons Rehabilitation Act 1999 1 minute. So sorry, the state therefore is required to either allot them a suitable land or a compensation in accordance with the orders dated 10th of November 2022. We are informed that the review application is posted before the High Court on 21st February 2025. We request the revision bench, which is seized of the review application, to take up the review application on the said date and decide it forthwith, so that the contempt proceedings can be taken to logical ends. Paragraph. We also request the revision bench taking up contempt petition to proceed further with the contempt petition after the review is decided. To expeditiously decide the contempt petition after the decision of the review application. Yes, you wanted to say something?
Small request. Government has already kept 50 crores in a separate account. If that can be deposited with the High Court, 50 crores, 63 crores. If that can be deposited.
You make a request there.
Now, give us liberty to make a request before that pensions.
It's always there. Yeah. Please for them.
If I had fourth, the computer showed it as listed on fourth. From all of it, we came, but it was not listed. And suddenly, actually, I got just a online notice only. So many of us couldn't come, and the airfares are very high. So
everybody is not required to come. Everybody is not required to come here.
She is the president of the Amasami Association. That's a victims of the this system. But therefore, this is a grievance. Many people mistake it as something in the report. No, it's a grievance which the litigants feel. I personally feel. People like me who are senior to judges of the High Court. This court.
No, people like you.
We have many of us are senior to the judges of this court. Yes.
Here.
Yes.
Yes.
So now the system treats us unfairly. This system. So, my lord, I have prepared, my lord, a chart. Here, I have prepared a chart.
We don't see that anybody gets a better treatment in this court merely because he has a gown, different gown.
My lord, your lordship is an exception.
No, everybody in the Supreme Court. Or in the,
that is not the perception. Ask her. That is not the perception. Your lordship knows, in Bombay High Court.
You can ask Mr. Parmeshwar.
Well, to get a matter listed, I very often go. When a junior lawyer, when they go for a listing, this is, they may not be knowing that in Bombay High Court to get a matter listed, even for a bail application, you have to be in the queue. Sometimes the queue runs beyond the court, and you get a date of 1 month. And on occasion, where Justice Naik is now practicing here. My junior came and he's not with me. Junior lawyer came and said, "There's somebody is in jail. Bail application was given a listing after 6 weeks or something." Then I went to the court and said, "This is bail application." This is I said, "Okay, what can I do? I gave a date. I will not change it. But what can I do is on that day it will be."
You know, Justice Naik used to sit in court till what time?
I know, my lord.
No. So the judges are also human beings.
No, I said.
So in spite of that, they are trying to do their best. Justice Naik never rose from the court before 7 p.m.
The story is Moses' father-in-law was much perturbed. Moses was sitting from morning to evening and dispensing justice. And Moses then, father-in-law advised Moses, appoint more judges. You don't have to do everything yourself. And Moses anointed others as judges. This Bible.
But it's not in our hands to appoint more judges.
Now you have lost to exercise the powers of the parliament. Now with the NJAC being set aside. None of the administration, governance, lawmaking, everything is in the hands of the court. A supreme legislature, a supreme executive which doesn't take decision behind the back of the people. When the electoral bond case on issues, I am the petitioners. But on principle, I am against that. When a parliament decides a matter, takes a decision, record of a parliament is binding on all. Because I am symbolically present. When a court.
Even Kerala.
I didn't practice I didn't have the good occasion to appear before his lordships much because no, my lord, I came to 19.
And you made an allegation that I did not hear it. I was wondering.
No, my lord, I speak the truth. If I said so, it is truth.
Yes.
I speak truth fearlessly. Come back me. What most can happen? But your life can be taken away. You can be imprisoned.
No, no,
Life. Yeah, one day you die.
Yes, life can be taken away, but you know, there's only one power.
I see my lawyer friends are so fearful of a court.
Nobody is fearful.
This is Vinod knows it. Justice Padmanabhan Swami, everybody feared. He was dreadful. But my lord, I said the same thing, what I am telling to your lordships in 1986. Somebody asked case. It's a reported judgment. But my lord, therefore the lawyers need to be fearless.
Lawyers are fearless.
No.
Lawyers have led the freedom movement of this country.
Lawyer, that was before my lord. I started actually coming to the court in 1979. I was a litigant. I was a litigant. 79, I went to as a litigant in Municipal Court, Pali.
Mr. Nedumbara, the Bible starts with the with the sentence that God said, "Let there be light," and there was light. We would love to have such powers. Can we just declare that the lawyers from tomorrow onwards will be fearless? Fine. What is this?
I say, I'm not praising, don't mistake me for that. As very popular judge, and because relief oriented. And I can see a change. Your lordship was different in Bombay. Your lordship exactly keeps time, 10:30. I told your lordships, one day when your lordship came at 12 o'clock, in the British Parliament, a minister apologized profusely, offered to resign when he was 1 minute late. So, my lord, I have become a fan of your lordships. No longer a critic. No longer a critic. Because, my lord, we all change. Every day I change.
Everybody has to change.
Everybody is changing, my lord. But some people, therefore, my lord.
Yes, thank you.
No, my lord, now.
Thank you, dismiss.
My lord, now the legal issues.
You are dismissed.
No, my lord, there is no estoppel against law. I file a petition tomorrow.
Yes, you are most welcome.
There is no estoppel against law.
Yes, no estoppel.
Issues has to be.
Yes, thank you very much.
But the life day, for whatever reason, the lighter way, but your lordships has to, because there's a grievance of the 99% of the members of the bar. Your lordship will dismiss after having a look at this chart. Just have a look at this chart. Look at the chart.
I might have changed here, but I have not changed one practice of not hearing the lawyers after the orders is passed. That I have been consistently following right from Nagpur.
There I give one example, my lord. The Supreme Judicial Tribunal was Holy See. And Holy See said infallibility. Why it is infallible? Because the Holy Spirit prevents the Holy See, the Pope, from committing any error.
Yes.
But the current Pope apologize for this Inquisition, that is today's contempt of court, Inquisition, and also for holy, that is crusade. Apologize. So judges repent. There's a
Mr. Nedumbara, wherever I was required, I apologize to the bar also.
Yeah, the locus it's a time for repentance. Repentance, my lord.
Yes, thank you very much. We'll learn everything from you in a better case. Yes, thank you.
Then, my lord,
Thank you.
It is so expensive, my lord. Even air ticket costs But not
You need not,
22,000
you need
or
not.
if not more.
You better get elected to the parliament and you pass an enactment removing this.
My lord, we will certainly. Certainly.
Yes.
We will not allow the, my lord, my health and life, God gives me life. I will pursue till, my lord, that is, it is said, drops of water follows a stone. Not because of his force, but persistency. Persistency. Defeated and defeated and defeated and defeated and defeated will pursue.
Thank you.
Because it is true.
Yes, Mr. Vijayawada, you can pursue the truth as per your perception now, but please permit us to.
I only pray that, my lord, let the doctors go in intention.
Please permit you to go to the next matter. Thank you. File before the High Court, we have in the judgment itself we have got given liberties. And in case if there is any breach, the jurisdictional High Court will be entitled to entertain.
Para number 93, the Honorable Court observed that it is also be informed that violation of any direction would lead to initiation of contempt proceeding in addition to the prosecution, Your Lordship. So that's why we have filed the petition, Your Lordship, for this Honorable Court. Similar nature petition is pending before this Honorable Court, Your Lordship. Page number 6 of my contempt petition, Your Lordship, I have quoted that.
Yes. But we find that the issue can be best addressed by the jurisdictional High Court. So we therefore dispose of the present petition with liberty to the petitioner to approach the jurisdictional High Court.
Your Lordship, in the meantime, I am.
No, nothing in the meantime.
Your Lordship, may I request to, in the meantime, third party interest may not be created my property, Your Lordship, because this is the legalized custom.
Go and file a prosecution. We have also issued all necessary directions. Send them to jail. Yes, thank you.
By at least minutes. The petition is a university. The cutoff date is 15th August. And the respondent had her internship completed thereafter. She made a representation. First, NMC rejected it. Then she has gone before the Honorable Court without making even an application before us. And there was a consideration then. When we considered, we have rejected. And she herself has said that similarly placed are 520 people. And that would open floodgates, the whole scenario go for a toss. In that context, we were constrained to stick to that one because it's a policy decision as my lords have held. My lords, may kindly see at page 21, your lordships have held that a similar application rejected, saying that there should not be an extension of the cutoff date. It will have a cascading effect on the academic session. So was the case at 28 and 32.
But annual 4 weeks.
We have to go with the scheduled online. This one.
Stay of the MP.
Stay. Wait for minutes.
Said graciously accommodated us. That's the problem I had submitted on the previous application also. So far as EG medicals,
No, this is a different matter. 34. Yes.
60. So far as 62 is concerned, the All India quota round 1, round 2, round 3. State quota of each state must, state counselling of each state must happen after the respective round of the All India quotas finished. So far as Madhya Pradesh is concerned, what had happened was, while round 3 All India quota was going on, counselling was going on, state is continuing to pursue. Even today it is pursuing as round 2. As a result of which, there are students who have occupied seats in that route and quit their seats in All India quota. We are round 3 All India quota students. You would have got those seats had the state counselling finished before round 3 started. We have already locked our options. This affects in 2 ways. One, we get better departments. Today we have anesthesia, dermatology, etc. We will get general medicine, cardiology, etc. That's one way. The other obvious and the more impactful way in which this is affecting us is the fact that we will get state seats instead of private college seats. Ideally, and all these years, what has been happening is round 1 of the respective state and central quota goes. So far as Rajasthan is concerned, this year this problem occurred and it was sorted out on the executive side. But Madhya Pradesh, even today, it continues to counsel. What has also happened is round 3.
Mr. Sharma, have you taken instructions?
I'm appealing for NHC, the DG has to answer, but I have instructions in the matter. Will may kindly turn to page 145 first. This is the time schedule for this year for postgraduate admission. It is always, firstly All India Council takes place, then the state, then All India, then state. What has happened is, the entire country, they have already conducted the third round. The state of Madhya Pradesh, because of this litigation, could not conduct the second round on time. This happens every year. One or two state has some in-service dispute, some counseling dispute. But that will not affect the All India counseling because, in case anything has to be done now, it will have a cascading effect in all the states. Because students have already taken part in the counseling and the counseling has already taken place. As far as All India third round is concerned, may kindly turn to page 82, there is a condition that after third round of All India counseling, because students get already 2 chances in first round and second round, they are not allowed to vacate the seats. So if you have chosen a seat and have taken a seat, you can't now go and take back whatever has happened. Because if the students are affected, the entire country, the litigation will start. Those people who have not secured seats in the All India counseling, they will start coming here.
So I had a suggestion to this. After one,
so wherever the seats are not taken in the state, that can be added in the next round because next round is also there.
So that's what his condition was. But then those seats will go vacant.
So there are some of us who will write to them saying that these are our seats. That seats and the seats which have fallen from the MP quota can be taken in straight. Kindly see page 50 for it. As of today, after I have been allotted a seat in round 3, I am debarred from participating in stray round completely. All I am requesting is anyway those seats are coming to stray round. Those seats which the MP students vacated, I'm just trying to find a solution.
What happens because when you vacate a state seat, a state candidate was eligible to it. You can't say that it will come in the All India quota.
No, I have taken it in the All India quota. I have taken it in the All India quota. So what will happen is, suppose 100 of us missed our bus because of the MP problem, and MP 50 students vacated it. So 50 seats are anyway going to the stray quota according to their rules. 1, 2, 3, and those seats will come to the stray quota. Those are better seats because they are in government colleges and from better departments. So what? I'm just trying to find a solution for these people. The Lordship's first PG medical seats. We are stuck with dermatology, diploma, etc. We would ideally like to be medicine, cardiology, etc. So I am saying our seats which we vacate and for this year will permit us to attend the stray counseling. So both our seats which we will end up vacating perhaps if we don't, if we pick up those 50 seats which the LP students have vacated, and those both can come to the stray quota. This happened before also. This happened before. There are orders of your lordships. Your lordships have tried to adjust the equities at some point of time. I am not saying disturb anything at an all India level. All I am saying is permit us to attend counseling the stray round. If we get better options, we take it. We take it. So do counseling for the seats that we will vacate in case we take up, and those 50 seats also. This is a way to solve this out.
Let me explain the problem very well. I am an All India student, but I missed All India seat and I have taken a seat in the state, maybe Karnataka or Rajasthan. Now all these seats are vacated and these are the better seats which I have taken.
Then they will also
that will have a cascading effect because all over India the students will start coming here asking for those seats. Let me again apply and leave the states. It will have a cascading effect in the entire country. There is the problem again. Wherever the vacant seats are there,
Lordships have done it the previous year. Lordship, can you see the
difficult of it.
Those are who have come.
Who is having with the state of MP?
Yes, madam.
You won't start.
Yes,
They are so much interested in medicine.
No, next year.
What I am saying is permit us to participate. I think those people have come to your lordships to permit us to participate in the counseling.
You are a doctor. Don't be so finicky about the specialization. You're getting it.
Because I am a DNB diploma, I get a medical MD seat automatically. It's a lifetime opportunity. Your lordship realizes that I can't even believe the DNB diploma now. After 3 years now, I have applied to PG entrance all over again. Plus, what effectively happens is lower rankers now get above us. We have 2,000, 3,000 ranks above all of them. They get the better seats and we end up having DNB diplomas. I just show that all of you. I can only would you also see?
I'll come at 12:30, so that we'll finish.
It's in part of the paper book itself. Would you also kindly see it?
Before my learned friend is showing, the order is wherever the state is the All India Council. This honorable court has extended and given them. But they were not allowed to leave the seat and then play with some other.
Page 34 to 35. Would you also kindly see page 35? An entire round was cancelled for the All India quota, not for state quota. I am showing each state. Please see page 36.
This is a different matter. Here, these students were not allowed to take part in the All India Counseling.
It's not as if there is no precedence in getting over type schedules. Every year there seems to be some problem. The states are at fault here because they disturb the schedule without the students' knowledge. An entire round of counseling was cancelled. And fresh problem. I'm not even asking for that. I'm not even asking for that.
Also see page.
You see, Mr. Sharma, page 36, para 2.
Yes, kindly
for the 142.
In the line of these regulation, which has been notified on so and so, students who have joined the course on second round of state counselling and round of All India shall not be eligible to participate in a mock up round. So these people are those who have already taken part in the counselling and taken admission, Milots.
But this is contradictory. You read para 2.
Yes, Milots.
You read para 2.
I'll explain what has happened.
Please read para 2 and 5 together and tell us how they go together.
What has happened?
Please read.
The court has heard the submission of the on behalf of Union of Union
Government.
No,
Clause 2 of para 3.
For 146 additional seats which seats which became available after AIQ round 2000 so and so, a fresh round of counselling shall be conducted. As special case, students who have joined the second round either of the state quota or the AI quota will be
At liberty to participate in the fresh round of counseling.
I'll tell you.
And now read para 5.
Yes, Milord. In the line of the regulation which has been notified on so and so, students who have joined the second round of state quota or All India round shall not be eligible. Milord, let me explain this, Milord. I'll just explain. Milord, kindly turn to page 82, Milord. Page 82, Milord. Milord, before last year, Milord, there were only 2 rounds of counselling, Milord. Now there are 4 rounds of counselling. So, Milord, earlier students were blocked after second round, Milord. Now the students, Milord, may kindly see page 82, middle of the page A, Milord. Middle of the page A, Milord.
Yes.
If upgraded, the candidate must take increase from round 2 and join round 3. Once joined, he cannot be upgraded or resign from the third round. So, Milord, what happened that time, Milord, wherever the counselling has happened, they were stopped. And wherever the student has left the counselling, they have not taken a seat in the second round, they were permitted in that round to take part in the counselling. It is not everybody, Milord.
This is with respect to the second round. The last is
It is not everybody, Milord. It was only those who has resigned the seat or who has not taken part.
So far as round 3
and these seats came later on, that's why this benefit was given. There's no student was allowed to leave the seat.
dismissed.
So I was only hoping that some way students are not at fault.
Sometimes
With all benefits, as if the students are at fault. The problem is the scheme will be, the counseling will be affected.
Because no, if we entertain the petition of these three, we'll have another 30 and then it will all go on.
And this is 2024, which has to be finished by August, the session will not be in February.
They are unable to open the street. Some casualties are there.
We get this opportunity once in 3 years. We can't drop out of this course once we get a diploma course because they have strict norms on locking. Once I participate in 3, I can't leave this state, I can't leave this. What I am saying is if you are accommodating the stray rounds, it's not, I can understand I come after counseling. Mr. Sharma, when is the
counseling?
Not counseling.
It's to start today.
Will start today, the next counseling. The problem is, the other state student will start coming and claiming for these.
This was only in Madhya Pradesh. It was not a problem in the other states.
People have taken all of the seats. If people have taken all